All rise. Court of Appeals, Division 1 is now in session.
Good morning. Please be seated. This is the time set for argument in Arizona Electric Power Cooperative, Inc. versus State of Arizona and Department of Revenue. Our tax number 16-0013. Each side will have 20 minutes within which to present their arguments this morning. The appellant may reserve some portion of that for rebuttal. However, it's incumbent on you to keep track of your time in that regard. We have read the briefs. We've been through the record. We've conferenced the case. So we're familiar, I believe, with the underlying facts and issues that you've brought before us. So please take that into account as you make your arguments here this morning. We are recording this argument, both audio and video, and at the conclusion of the argument, actually in the next few days, the video will be posted on YouTube, and you can look and see how you did. But as you approach the podium, please, since we are recording this, please identify yourself and your client for that recording. With that, Mr. Mooney, you may proceed.
Thank you, Your Honor. Good morning. For the record, my name is Paul Mooney. With me at counsel table is Bart Wilhoit. We represent the plaintiff appellant, Arizona Electric Power Cooperative, Inc. Seated in the gallery immediately behind me is Mary Jackson from Arizona Electric Power, who drove up from Wilcox this morning for the oral argument. So I just wanted you to be aware of that. She's the taxpayer in this particular case. The issue before you in this appeal is whether the tax court committed reversible error in dismissing EPCO's, and I'll refer to them as EPCO's timely filed tax appeal from the State Board of Equalization. The clear answer to that question is yes. The reason is because the statutes are clear that the taxpayer is allowed to file an appeal from the final decision of the State Board of Equalization within 60 days from the date of the mailing of that final decision to the taxpayer. In this case, this appeal was filed depending on what date you use, whether it's December 7th or December 8th, and there is some dispute in the record about that. It's irrelevant because both dates are within the 60-day required period. The tax court mistakenly ruled that this case was essentially governed under provisions of the Rules of Civil Procedure. I can understand why the tax court might have been confused about that, but the Supreme Court of Arizona answered the question in definitive terms many years ago. I say many years ago now because that was a brand new decision when I started practicing law. In the Cypress Pima mining case, the Supreme Court said that in property tax appeals, the right to appeal is statutory and the method provided by the legislature is exclusive. Now, what's interesting about that case that may not be apparent from simply reading it, and it's clear enough on its face, is that the lawyer representing the Department of Revenue in that case was one James Powers. Jim Powers was my partner for many years when I was at Fenimore Craig. The Powers Ehrenreich firm merged with Fenimore Craig in 1985, and Jim was a fine lawyer. I used to razz him about this decision because, how did you miss this? And he said, basically, I missed it because I assumed that when the appeal was filed, I could file a counterclaim. And under the Rules of Civil Procedure, he could. But the Supreme Court in that case ruled very clearly that the statutory appeals procedures are exclusive and they're mandatory. And the only way, as they held in that case, that the department could raise that issue was in the manner provided by law, the way the legislature prescribed.
Mr. Mooney, give us your best argument as to why the amended findings of fact, conclusions of law decision from November 16th is not the final decision for purposes of appeal.
Well, for multiple reasons, not the least of which is the fact that that's what the board said was its final decision was the December 7th or December 8th decision. Mr. Shook, who's the chairman of the board, gave a declaration to that effect, which is in the record, and this is here on a motion to dismiss, in which case the court has to construe all the evidence in the light most favorable to my client. There is no dispute.
I'm not sure that Mr. Shook's version of what the law is all that informative. So.
No, I'm not asking about Mr. Shook's version of the law. I'm simply taking his statement of fact. What Mr. Shook stated under oath in his declaration is, Attached as Exhibit A is a true and accurate copy of the board's final amended notice of decision. That electronic corrected notice of decision showing a mailing date of December 7, 2015 is also available on the board's website and gives the web link. I went on the web this morning. There are 3 places on the web where that decision appears, and in every one it says mailing date December 7, 2015.
Okay, what I'm really interested in is looking at the November 16th document entitled The Amended Findings of Fact, Decision, and Conclusions of Law. And I want to hear from you as to why that document on its face is not a decision from which the taxpayer should have timely filed their notice of appeal.
Because it's not the final decision of the state board. Final means last.
It's just not the last one.
It's not the last one. I mean,
So does your distinction, or does that argument allow for any distinction as to the materiality of a change or need there be a change? Say the board reissues the same decision later. Does that become the final decision?
I believe the way the statute is written, which is what governs this, the legislature determined that it is the mailing date of the final, i.e. last decision of the state board that controls the calculation of the 60-day period. There's no other way to read the statute.
So there doesn't even need to be a change of any sort.
In theory, that's true. There was a change here, of course. Mr. Shook testified that what he noticed was there was a mistake in the November 16th decision. In particular, the wrong party was designated.
Well, not in the findings of fact and conclusions of law.
The findings of fact and conclusions of law are not part of what the decision is. If you go and look on the website, you will see a copy of the notice of decision, and that document is also appended to the affidavits. It is a card. It is a.
Yeah, we've seen that. Is that what counts then?
That is the notice of decision, which provides the date of mailing of the board's decision. The findings of fact and conclusions of law are something that are prepared after the fact. I've done these in hundreds of cases where we have centrally assessed appeals, where the board then says, can you just send us something that says, because we've got boilerplate that goes into our standard notice of decision, can you send us that?
So then your position is that the controlling document from which the appeal flows is the notice of decision that's posted online and not the signed decision?
That is correct, because that has always been the case.
It's your position that the findings of fact document is not a decision?
No, my position is that the findings of fact are prepared at the board's request after the board has heard and decided the case. They typically ask the party who prevails to prepare those and to submit them to the board. The board didn't always do that. In the old days, all the board did was issue the card stock.
At that time, there was no internet, right? So there was no posting as we have now.
Correct. That is true. And interestingly, the card stock still looks exactly the same as it always was used before, and it actually has findings of fact and conclusions of law on it. They're in microscopic print. They're like an 8 font or a 6 font, but they're stated there on the notice of decision that is actually sent out by the board to the taxpayer. The findings of fact, if you look at the actual document, what they state is that if you want to see that, let's see where I've got that here.
Doesn't the notice of decision itself refer anyone looking at it to the findings of fact? And it states at number 5,
yes,
a letter.
You and I are on the same page.
A letter decision has been issued by the board to the petitioner or respondent. Any party interested in viewing the decision itself, or obtaining a copy of the decision should contact the board. Isn't that sending us back to the findings of fact decision?
That's what the boilerplate says. However, the boilerplate also has findings of fact and conclusions of law, and that statement is simply say if you want to see that document that we have, you can ask for it. This is the document that's mailed to the taxpayer. This is what the statute refers to. This is the document, the only document that's mailed to the taxpayer, that says a mailing date of December 7th, and it says corrected in this case, has a date of December 7th, and it has the summary conclusions as to what the board did, that they had jurisdiction to decide the case, the petitioner filed the appeal, the respondent stated the value is correct, and a letter decision has been issued by the board. They call this a letter decision.
You said that the notice of decision is the only document that's mailed to the taxpayer?
This is the only document, the one that you and I were just reading from is the only document that's mailed to the taxpayer. That is correct.
And the findings of fact are not mailed?
They are not. In fact, that's what the document says. It says you can request them. A copy of the decision anybody who wants to get a copy of the decision should contact the board. So you'd have to actually get this document, be aware of the decision. This is what tells you of the decision. This is what triggers your appeal deadline. And if you want to have more, the document says you can ask the board for it.
Doesn't the document itself say that it's mailed?
The document,
The findings of fact and decision, doesn't that at the back say that it's mailed to the parties?
it does in the mailing certificate at the bottom. It does say that. Yes.
But it's not actually mailed?
Well, on this record, you could draw a lot of conclusions about that. For example, the November 16th one has a mailing date on it of November 14th.
Right.
And yet there's evidence that it wasn't actually mailed until the 16th. The one that says December 7th actually was mailed according to the declaration on December 8th.
But I thought you were saying that the findings of fact and conclusions of law normally are not mailed.
Normally, what is mailed to the taxpayer in the ordinary case, in the Board of Equalization hears hundreds, if not thousands, of appeals in a year. These are administrative appeals. The lion's share of those involve locally assessed property. The only cases I'm aware of, having done this now for a very long time, where separate findings are prepared are in the centrally assessed cases, the cases involving
the big ones.
Department of Revenue cases that involve mines, utilities, and the like. And again, that's a recent practice. It's something that the parties have been asked to do by the board after the hearing is over.
Is it correct that the findings of fact and conclusions of law may or may not be mailed to the parties?
Well, I suppose you could draw that inference. I don't know that they don't trigger any deadlines in my view, because the official document that gets mailed in every case is the notice of decision.
And if we're talking about a rule that we're going to interpret.
Correct.
Or a statute that we're going to interpret.
Right.
For all time, for all of these decisions of the
Correct.
state board, then we need to, I would suppose we need to be cognizant of the fact that in many cases, what you say is most cases, formal findings of fact and conclusions of law are
well, they
not prepared.
They are actually
mailed.
on the card too.
Right, but I'm talking about.
Correct. The separate document is not generated in all cases. It's generated in centrally assessed appeals, and it's done after the hearing is over. But the document itself says that what gets mailed out to the parties is the card stock that has the decision on it. And if you want to see the other, you can ask for it.
And I want to go back to your position, which is it's the last document that's
correct.
Notice that's mailed out that triggers the appeal rights. So hypothetically, if a decision is reached by the board, they create this notice, let's call it that, and some days later, or even a month or two later, the taxpayer calls up and says, could you reissue that?
Well, that
board have the ability to do that and extend the appeal period?
I do not believe the board has that right. Those aren't the facts in this case either. We have the attested.
Well, I'm just trying to put some arms around your suggestion that it's the very last decision. How would a taxpayer know when the last decision is?
Well, presumably the board is an independent agency under state law. They have duties that are prescribed by law. I presume they follow the law. They have a lawyer, Rex Nowlin, at the AG's office who advises them, whose name appears on a bunch of these emails related to this amended decision. So I presume they're acting in accordance with the law. I will give them the benefit of the doubt on that. I do not believe that it's accurate to suggest that a party could pick up the phone and say, hey, could you just reissue a new decision? I do not believe the board, in my years of experience dealing with the board would comply with such a request, because I don't think there's any basis for it. So if the question you're asking is, could that happen? I suppose anything could happen. But that isn't what happened here. That's not what's in this record. What's in this record is that the clerk noticed a mistake. He corrected it. He mailed out another notice of decision, which shows up as the date of mailing of the final decision of the board. It's final in the sense that it is the last in time. Could there be a later one? In theory, I suppose there could be. There wasn't here. The appeal was filed within 60 days of that mailing date. That should be sufficient to satisfy what the Supreme Court has said is the exclusive statutory procedure that we follow in these cases. It's our position that we shouldn't be reading in to the language that's clear. I mean, I've been in front of this court many times arguing much more ambiguous and complicated statutes than one that says final decision. The mailing date of the final decision is pretty clear on its face, I submit.
Well, isn't though, I can't identify the number of the statute, but isn't there a statute in the same vicinity that says a decision is final when it's not appealed from for
Within-
60 days?
within 60 days, you are
So
correct.
That's pretty circular, isn't it? If you can appeal only a final decision, but a decision doesn't become final unless you don't appeal it.
Well, let me make it really clear. If this decision came out on December the 7th, and one of the parties to this action, in this case, it would only be the taxpayer because it was a no-change decision. There was no, the department was not an aggrieved party. But if the board had simply did what they did on November 16th, and the taxpayer had filed an appeal before December 7th, then the board would have been divested of jurisdiction at that point. Or on December 7th, they act and an appeal is filed the next week. Then that divests them of jurisdiction. The point is there is a cutoff. The suggestion in one of the points in the brief is that this could go on indefinitely. I submit that is a virtual impossibility. That's not how the board works. That's not how these cases work. This is simply a very, I would submit, unusual pattern of events that it relates to a decision that got amended twice. I've been doing this a long time. I haven't seen one of these before. But the fact is, my client brought a timely appeal because they appealed within 60 days of the mailing date that shows up as the final decision of the board. It shows up on their website even today, 3 separate places, mailing date December 7th. I don't see how we can draw any other inference from the facts in this case unless we're trying to invent facts that don't exist. And I don't know if that's responsive to your question or not, Judge Winthrop. I tried to be. I'll save my remaining time, if I may, for rebuttal. Thank you.
Very good, thank you.
Good morning. May it please the court, my name is McKayan Mahoney, and I'm here on behalf of appellees. At issue here is whether EPCO timely filed its appeal under ARS 42-16203C. It is our position that they did not. Just to kind of give you an understanding of why this is important to the department and to the counties, the tax calendar is very cyclical, and it happens year after year after year, and that's what allows the government to run. That's how we collect money so that we can run the state. And that's every year it's pretty much the same. So the department sends out a notice to taxpayers that they have to submit information. The taxpayers send that information into the department. The department comes up with an initial value for centrally assessed properties. They may have an informal conference with the taxpayer. And then at the end of August, or in August, the department issues its final decision on what the value of a property is going to be. Once it does that, the taxpayer has 2 options. It can appeal directly to court by December 15th, or it can appeal to the board by October 1st. All of the board hearings are typically heard in CVP appeals from November 1st to November 15th. The board has authority to issue its decision by November 15th, and after that date, it has no more authority to issue decisions because under the statutes, its jurisdiction lapses.
There's some suggestion, though, that it is typical for the board to issue its decisions after that date.
There are suggestions, Your Honor, but there are no facts to back that up in the record, and it's my understanding that it's not. So it's either Ken Love or I are AGs, and we represent the department. And every year, George Shook tells us, you need to get us these decisions because we have to get them issued before November 15th. That's our cutoff date. And so in this case, we had decisions for multiple parties that we sent to him. And for some reason, Mr. Shook, I mean, this is all me testifying, so I don't know how much you could take of it. But for some reason, Mr. Shook decided that he wanted to change some of the language in the decision. When he did that, he cut and pasted the value from another taxpayer into this taxpayer. And when you look at the emails, you'll see he says, correct, cut and paste error. And so what he did was he kind of made a mistake in how that was transferred over. We saw that November 15th was a Sunday here, so under the statutes, they had authority to change until November 16th. So everybody emailed, everybody understood exactly what was happening, and they amended that decision and got it out with the proper value in it. So my experience, on that is that no, they're always completed by November 15th or the 16th if it's the Sunday afterwards.
Okay, so when you made that argument in the answering brief, that as a matter of law, the board doesn't have the power to issue a decision after, I didn't have the power to issue the November 16th decision here. The taxpayer argued, well, come on, as a matter of fact, the board's decisions often are issued after that date, so that's really not a good argument. But you would, since you didn't get a chance to file a cert reply, you would say, no, that in fact does not happen.
That does not happen in my experience, Your Honor.
Okay.
So the board finishes its hearings by November 15th, and that's important because the statutes also go on to say that by the fourth Friday, the board has to transmit any changes that it makes to the tax roll, to the department and the counties, and then the county assessors actually finalize the roll on December 20th of every year. So if the board kind of had jurisdiction to change its decision for 60 days, that would allow the board to actually change the roll after the assessor has already certified it.
What's the statute that says by the fourth Friday?
The fourth Friday would be, let me see here. I'm not sure that I have it written down, but it's in my brief. And as far, 4216166. And 16167 notes that the board makes changes to the roll.
Okay.
And 15153 notes that the assessor must certify the roll by December 20th.
So, just hypothetically, if the board issues its decision November 15th, that's sort of the last day, as you've identified it, and thereafter, someone notices there's an error in that decision, they can't ask the board to revise or amend its decision?
They can, Your Honor, but the point I think here is that the tax calendar is very important, and it's important that it goes on for all these various reasons. And if we start to make exceptions to how these statutes apply, that can kind of unwind the tax calendar, which will be very harmful to the state. And I guess unless you have any questions, I'll get into the actual argument.
Well, what I hear you saying, this unraveling might address the proposition that the board can keep issuing repeated decisions. Well, what you're telling us is that's not going to happen because there's a calendar that needs to be followed. But to answer Judge Winthrop's question, a taxpayer who notices a plain error, but it's a material error, and if the taxpayer is going to appeal it, it needs to be, you need to fix it, could come back 30 days, 50 days later and ask for a corrected decision, right?
Your Honor, they could, but if they were going to appeal that decision, it wouldn't really make much. I mean, you could do it, but when it gets to the Superior Court, it's all de novo. It's totally a new trial. So this is almost kind of like a.
Well, that's not a very good answer. I mean, I'm sorry. What is you're saying why the taxpayer wouldn't want to appeal, but why the taxpayer wouldn't want to raise the issue. But say the taxpayer does want to raise the issue. Say and the board says, oh yeah, that's right. We need to fix it. The board issues a corrected decision. Is that an appealable decision if the thing that is corrected is a material change?
Well, and I think this is what the court kind of is here to decide, right? What is it? What is a decision? And thank you for that, because it'll go right into my argument. And that's, the court is here to decide what this statute means. And I think that we can look to case law in order to understand what that statute means. And I don't think our argument ever was or the tax court ever said we are following the rules of civil procedure. I think what the tax court and what we should all do is look at the case law to understand how do we interpret this word final decision? What does it mean? And to answer
your position at the Superior Court was that the November 13th decision was the final decision. That was your position initially, correct?
So at tax court, what happened was we got the complaint and we were a little befuddled because we had never received anything before. So when we originally moved to dismiss, we said, hey, we'll go with the November 16th date, give them the benefit of the doubt. But then our reply brief, we argued, well, it's probably the 13th, but the 16th, either one, you filed late.
So what is your position today?
I think today the position would be that the November 13th decision was the final decision, because that is the decision date that the board issued its decision and mailed it to the parties.
Even with a mistake of about $40 million?
Yes, Your Honor.
That's still the final decision in your position?
Yes, Your Honor, because we can look to case law to kind of understand this. And the case law states when you look to judgments that are appealed from a superior court to the Court of Appeals, if it's like a clerical error or it's something that the parties agree on, that what the actual decision wasn't changed, it was just some mistake that doesn't actually go to the root of what the dispute was over, then that can be changed without affecting the decision, because no form of decision changed.
This was a $40 million change.
It's a $40 million change that all parties and the board knew should have been corrected.
The fact that it's undisputed doesn't mean it wasn't a significant change. On appeal, 2 years later, what are the courts to look at, to look at this hard copy and say, yeah, well, it says 140, but really that's not what it was. We can't do that. We need certainty.
I agree. And, you can go and make a clerical change to a decision without affecting its finality as a decision, is what I'm stating. And so when we look at the court cases, that's what they state. They say like a superior court can go in and it can amend a number if it got that number wrong without changing the appeal date for an appeal up to the Court of Appeals. And the way that you think about that is you look at what a decision is, and that's a determination that is arrived at after consideration of evidence. And everybody agrees, the board, appellants, appellees, what the number was supposed to be. The board issued a no change decision. It was just the transcription of that was an error.
So let's talk about what is a decision in terms of the two documents that we've been talking about here today, the notice of decision versus the findings of fact decision and conclusions of law. What is the decision from which the appeal flows?
Appellees would assert that the findings of fact, decision, and conclusions of law is the decision, and that is mailed to the parties. And actually,
is that mailed in every case?
That is mailed in every case that I'm aware of. It has to be mailed to the department under 40.
So you're saying in every case, in every evaluation case that comes before the board, there is a document called findings of fact and decision and conclusions of law that is mailed to the parties.
In CVP cases, yes.
But not in.
I don't litigate those cases.
Well, if
Your
we're
Honor.
if we're to interpret a statute, shouldn't the interpretation apply to all of the cases?
Well, in this circumstance, because the department's appeal avenue, an appeal from the department is different from an appeal from the county, I think that you could restrict your decision on that basis.
But we're interpreting what a final decision is, as issued by the board.
Yes, Your Honor.
And so that may be, your position is that may take a different form depending on the issue before the board.
That may be correct. The only issue that we have before us here is an appeal from the department's valuation to the board, an appeal from the state board's decision related to the department to the tax court.
Since I take it that there is posted on the website a notice of decision for every decision that the board issues, including non-centrally assessed cases, what's the problem with us interpreting the statute's reference to final decision to mean the notice that's posted on the website and mailed, as opposed to the findings of fact and decision and conclusions?
Well, I think all of the notices actually state that a letter decision has been issued to the parties. And so since I don't know what happens in county cases, because I don't represent the county in those cases. I don't know whether the board asks them, because it may not even be the state board that the county appeals to. The county can appeal to the specific board of supervisors or to the equalization, the county board of equalization in that county. So there may be differences to county. That's why I don't feel comfortable speaking on this, because I can't identify a totally separate appeal avenue and tell you what's happening there, because here it's specific to centrally valued properties valued by the department and appealed to the board. I would say that all of the online notices or notices state there is a decision that has been mailed. In all centrally valued cases, we have a findings of fact, decision, and conclusions of law that are mailed to the taxpayers.
And so so the position of the appellant is what is the final decision from which the 60 days begins to run is the last decision. What I hear you saying is that it's the state's position that it's the first decision that becomes the final decision, regardless of whether any change whatsoever is made in the decision going forward.
Well, I think when we think about this issue, we really need...
Is that the position of the state?
Well, I think Magma Copper is controlling on that point. And Magma Copper states that when a board issues its decision, its jurisdiction thereby is terminated. Or when an administrative body issues its decision, its jurisdiction is terminated. So after November 13th, when the board issued its decision, it no longer had jurisdiction over this appeal. It was terminated.
I'm not speaking of the appeal, the case, you mean?
Over the appeal to the state board, sorry.
Even if the, thanks, and that was my mistake. So the board has no power to fix an error even during the 60 days before an appeal is filed?
I would agree that the board cannot change its decision. I don't think that correcting an error is changing the decision.
Okay.
And that's kind of the issue here. And I think that's important, because what appellant is trying to say is that an appeal to court shall be taken within 60 days after the final mailing of the final decision. The decision is what the board decided.
So you're saying, on the one hand, the board lacks the power to make a material change, to make a non-clerical change. What's
correct? It cannot go back in and reevaluate its judgment over the appeal.
And therefore, any change it does make must be non-material and doesn't count in terms of, it doesn't affect the time within which to file an appeal.
Correct. And I think Magma Copper is controlling on that, because in that it says, I can get you the language here. It states, inferior tribunals acting judicially cannot grant a rehearing, and their jurisdiction terminates with their decision. It logically follows, since the tax commissioning was exercising a judicial function thereupon entering said order, it exhausted its jurisdiction. So here, when the board issued its order, it exhausted its jurisdiction. And because of the funky way that property tax appeals work, they can appeal to Superior Court de novo, and nothing that the board said essentially controls how the tax court would look at the case, because it's a totally de novo appeal to the tax court. Taxpayers kind of make an argument we can't look to civil, the cases on civil rules and things. I don't think that is correct. If we look at Thiel King versus Kirchner, it suggests that a court can look to interpretations of the civil rules if they're not inconsistent with or complement the administrative rules, which I think they do here. And then, I really do think that Magma Copper controls here when it says, the jurisdiction ends. You've got the 13th decision. Even if you don't want to find that the 13th decision was the final decision because it changed the value because of a clerical error, the board's authority terminated under statute, which appellants say we must strictly follow the statutes. The board's jurisdiction terminated at the latest on November 16th, and that November 16th decision conveyed everything correct about the material everything that is material to this appeal was correctly in that decision.
It doesn't matter from your perspective, though.
From my perspective, no. But if the court was going to make a different decision, I would say November 15th is the drop dead date for them to change anything. Unless the court has any other questions.
Oh, thank you, counsel.
Thank you.
Mr. Mooney.
Let me cover a couple things that were just said. First off, the board chairman is granted statutory authority to review and amend its decisions, ARS 42-16-164B. That is an explicit grant of authority to the chairman of the board to review and amend the board's decisions. So that's one point. Point two, we heard about the calendar and how critical the calendar is. First off, even Mr. Mahoney would agree that the taxpayer could have filed an appeal here within 60 days of November 16th. That would be January the 15th. That date is a month and a half later than the certification of values that he just referenced. Moreover, the taxes on those values are not levied until the third Monday in August of 2016, some 8 months later. And the taxes aren't payable until November. So the reality of this calendar being so critical, and somehow this all has to be final before the values are certified, simply doesn't pass muster, because even under their version, we would have till January 15th to appeal. So simply not a legitimate reason. Third point, the DOR claims it's now befuddled because it didn't know what its position was. Well, in reality, its position in the tax court was that it was the second decision that controlled. Its position on appeal is that it's the first decision that controls. And our position is it's what the legislature said, the final decision, i.e. the last decision that controls. What are we to do? Guess? Is the policy going to be that the statutes are going to require the taxpayer to guess in the case of an appeal where there are multiple different decisions? Because in every one of these appeals, every one, without fail, the notice that comes from the board says this in the very first line. The board convened at 1 o'clock p.m. on 11/13/15 and reached a decision. And then it says date mailed, December 7, 2015. It is the mailing date that the legislature prescribed as the trigger. It is not the oral decision announced by the board following the hearing. Because if it was, then there wouldn't be any insurance of due process. Because otherwise, the legislative language is completely superfluous. Are we going to construe the word final as meaningless? Because under the department's position, it's completely superficial. If the decision date is November 13th, why do we need the word final? Why would we ever need the word final? What's the point of that adjective? It has no purpose whatsoever, and we're not supposed to construe statutes as superfluous. Last point, what the tax court said in its ruling is very clear. This is a quote, and he's quoting from a case. Quote, where successive judgments are entered and the later judgment represents neither a material change of the earlier judgment nor a new exercise in discretion, the time for appeal is counted from the earlier judgment, close quote, citing the Fields case. That simply has no applicability here. Under the Supreme Court's decision in Cypress-Pima, we're not governed by the rules of civil procedure that would apply to modifying a judgment under Rule 60 or under Rule 59 or under Rule 56. It doesn't really matter what rule of civil procedure we're talking about because these cases are not governed by the rules of civil procedure. These are statutory creatures. They are created by the legislature, and the legislature has prescribed the mechanism you have to follow. There is no doubt that Jim Powers was well within his rights in asserting a counterclaim to a complaint under the rules of civil procedure. But the Supreme Court said, no, you have to appeal from the decision of the board timely, as in within 60 days of when that decision was sent to you. That's the law. Now,
what's your position about the Magma Copper case that counsel cites? I didn't see a response to it in the reply.
Well, first off, I don't believe the Magma Copper case changes anything I just said. If it's the Magma Copper case I'm remembering, and
I think it's the real old one.
The really
old
one.
77
The
Arizona.
fact is, The statute, to me, is what controls. Magma doesn't say anything different than that, because the Supreme Court interpreted the very same language, although it's been recodified since then, in the Cypress Pima case. The case that we've cited is the controlling decision on when you appeal from the state board. I don't believe Magma Copper says anything that refutes that.
Okay. What I heard counsel say is that the rule of the Magma Copper case, the 1948 Magma Copper case, is that an agency is deprived of
Jurisdiction.
the power.
Yeah, well, that's
No power
overruled by
to
the
amend.
statute. Doesn't the statute address that here, 16164B, that says
The final.
the chairman of the state board has the ability and the right to review and amend the board's decisions? I mean, that would clearly supersede whatever Magma says to the contrary in 1948, because the present property tax scheme was adopted in its earliest iteration in 67 and then amended in 80, and it's been amended several times since then, but mostly just recodified.
So
Okay.
I know we're out of time, but that last point about the statute, about the authority of the executive director, you're not suggesting that he or she has the ability to make a substantive change to a decision that's already been issued?
Says he can review and amend decisions, and in this case, he reviewed the decision according to his declaration, saw there was a mistake, and amended it. He's attested to what he did and why he did it. And I believe he acted within his power under 4216-164B in doing that. There's no suggestion here that he did something inappropriate or that he did it to extend the appeal time.
Thank
I
you.
think that's the answer to your question.
Thank you, counsel.
Thank you.
Appreciate the arguments presented here this morning and the briefing on this matter. We will take this case under advisement and issue our decision in due course. We're going to take a short recess to allow parties for the next case for argument to come forward and get set up. Thank you.